Hello everybody, Delene Sheesby here. Up to now we've had 7 short videos in which we have looked at the various sections and the proposed amendments to the Occupational Health and Safety Bill. And those amendments are the amendments which the public have had to, or given the opportunity to give comment on. The format that I'm going to use today is slightly different. I'm going to use the format which the SIOSH Technical Committee have used. They have used a format which, upon completion, they have now submitted their comments to the Department of Employment and Labour, to the Chief Inspector, Mr. Tupusana. And as I say, I'm going to use that format. And I will jump straight to the sections where there have been significant changes, so I won't deal with every single little thing. So not too many changes when it came to sections 21, 22, and 23. 21 was general prohibitions. 22, we had the sale of certain articles, and 23, certain deductions prohibited. So I'm going to have a look and start on the section 24. So we have 2 columns here. The first column was is the current legislation, and then on the second column is the changes or the proposed changes to the OHS Amendment Bill. Section 24, report to inspector regarding certain incidences. We're talking about incidences which have occurred at work or arising out of or in connection with activities of persons at work. So you will see there's a slight change in A and in B. So for those of you who have been involved with major hazardous incidences, and where major incidences have occurred, you will recognize it. You will see that in B, the definition, a major incident occurring, has for some reason been removed. Right, so what we are saying at this moment in time, in A, any person dies, becomes unconscious, suffers a loss of a limb or part of a limb, or is otherwise injured or becomes ill to such a degree that the person is likely either to die or to suffer a permanent physical defect, or likely to be unable for a period of at least 14 days either to work or to continue with the activity for which the person was employed or was usually employed. That has to be reported to the Department of Employment and Labour. B goes on to say, also to be reported, in the course of an employee's employment, an incident occurred which resulted in personal injury, illness, or death of the employee, or the health and safety of person was endangered, and where hazardous substance or biological agent was spilt or released. Please take note of these changes. They are quite significant. It also goes on to say, to be reported uncontrolled release of any substance under pressure, machinery or any part thereof fractured or failed, resulting in flying, falling, or uncontrolled moving objects, or machinery run out of control, shall not appear. It shall not apply in respect of a traffic incident on a public road, and an incident occurring in a private household, provided the householder forthwith reports the incident to the SAP, the South African Police. Take note that there's a bit of a change here. We would have to include the domestic workers at one stage, which means that an employer of a domestic will be required to report serious workplace injuries which have occurred in that workplace, being your own home, if you have got a domestic working in your home, which will include death, which actually has occurred in many homes, particularly with regards to electrical installations, amongst other things. Also to be reported is the employer or user or self-employed person shall provide the department with a copy of incident statistics annually on the first day of March each year. The incident stats shall include stats for contractors that occur while working on the employee's premises. Of course, now that means that the department will have to provide some type of format for the reporting to take place. So it actually becomes a good cross-reference, checking to see that these stats are being reported from both sides, both from the employer and from the contractor. Section 25, this we are talking about occupational diseases. So some changes here: a medical practitioner who examines, treats a person for a disease described in the 3rd schedule of the Compensation for Occupational Injuries and Diseases Act, or any other disease which the medical practitioner believes arose out of that person's employment, shall within the prescribed period and in the prescribed manner report the case to the person's employer and to the chief inspector, and inform that person accordingly. Now, this new the proposed changes doesn't actually mention the scope, or doesn't make clarity of the different applicable diseases. I think it should possibly have reference to the COIDA, not just reference to COIDA alone is insufficient. Victimization is forbidden. There you can just read it for yourself. Number 27, designation and functions of the chief inspector. That one you can read for yourself. Yeah, designation of inspectors by the minister. So an inspector who is designated in terms of this act and in terms of this particular section will have to have a card which is signed by or on behalf of the minister. That card will stipulate the bearer's name, that person's name, and it will have a unique number, an identity number, a photo of the bearer, and the designation. So if an inspector comes to your workplace claiming to be an inspector, the inspector must first show or have his identity card signed off by the inspector available. You are able then to verify the validity by phoning the provincial chief inspector or the health and safety specialist for that province. Functions of the inspector. An inspector may, for the purpose of this act, without previous notice, may enter your premises to go and perform some type of inspection. Now, this will eventually also include your domestic worker. However, we are totally aware of the constitutional rights to privacy, especially when it comes to your own private home. However, obviously, an inspector will have to make this arrangement with you upfront to gain access to your home premises. It would be possible in these instances to issue an administrative fine in terms of Section 37, as indicated in that Schedule 2. You will recall we actually had a look at those administrative fines. So when the inspector comes into your premises, they might need to take photographs or make some kind of audio visual recordings, whatever which may be relevant to the inspection or to the investigation which they are conducting. We need to note, of course, that if the inspector removes any items such as documentation or books or whatever the case may be belonging to the owner or the employer, that inspector must, as soon as possible, return those items back to the owner of the item. Upon completion, and subject to Section 40, upon completion of the inspection, the inspector would be required to issue a copy of a report with reference to that inspection, and that report would have to go to the employer, the health and safety representative, the representative of the trade union for that workplace. In the case of construction site, it will be the construction client, the principal contractor, or any other contractor on the site applicable, and to all persons in that particular paragraph. Just skipping down to section 31, investigations, to the relevant parts. So we're saying an inspector shall investigate the circumstances of any incident which has occurred at or originated from a workplace or in connection with the use of plant or machinery which has resulted, or in the opinion of the inspector could have resulted in the injury, illness, or death of a person. So for the purpose of this investigation, the investigator, the inspector, may subpoena any person who should appear before the inspector concerned on that day or at that place, whatever, and then give sufficient evidence regarding that particular incident. And then upon completion of the investigation, the inspector, the presiding inspector, would have to submit a written report with reference to that inspection, together with all relevant sworn statements, documents, and information gathered during the investigation, to the provincial control inspector. After consultation with the chief inspector, submit that report to the National Prosecuting Authority. The National Prosecuting Authority shall deal with that particular information and that report in accordance with the provisions of this Act. I'm going to jump right down to section 35. You can read the others previous to this yourself. So section 35, appeal against decisions of the inspector. So a person aggrieved by a decision taken by an inspector in relation to a notice or a directive served may appeal against such a decision which the inspector has made. A person who wishes to appeal in terms of section 1 shall within 14 days, no longer 16, 14 days after the delivery of the inspector's decision, lodge an appeal with the chief inspector. Now, there is a specific process you have to follow. Informal email to the inspector about your appeal is not within the process. It is just going to possibly be ignored. It has a lot to do with the evidence that you have as an employer and the evidence you have which you want to submit with your appeal as a result of the decision made by an inspector, and recommendations or any recommendations an inspector may have made when serving the notice or directive. And as I said, the NPA make the final decision. We can also have a quick look at section 36, disclosure of information. And we'll see here there's quite a few significant changes. Section 36(1), whenever an inspector performs any function in terms of section 31, that is your investigations, to supply information or report to a health and safety rep, health and safety committee, or third party, the inspector or presiding inspector shall not disclose information that is private or personal information relating to an employee unless the employee consents in writing. Then coming down to section 37, acts or omissions by employees or mandatories, which reads, section 37(1), whenever an employee does or omits to do an act which it would be an offence in terms of this Act for the employer of such employee or user to do or omit to do, A, in doing or omitting to do that act, the employee was acting without the connivance or permission of the employer or any such user. That hasn't changed. B then says, it was not under any condition or in any circumstances within the scope of the authority of the employee to do or omit to do an act, whether lawful or unlawful, of the character of the act or omission charged. Then we have a change in C, which now reads, all reasonable steps were taken by the employer or any such user to prevent any act or omission of the kind in question. The employer or any such user be presumed to have done or omitted to do that act and shall be liable to be convicted and sentenced in respect thereof. And the fact that he or she issued instructions forbidding any act or omission of the kind in question shall not in itself be accepted as sufficient proof that he or she took all reasonable steps to prevent the act or omission. What a big change. This is an interesting one. Section 37.2. Section 37.2 is still there. It's still there. That is the section where you have entered into a contract with your contractor, which places responsibility with them to ensure compliance. If you have a look at section 41, and I'll go down there in a moment. Section 41, it says this act is not affected by agreements. That section is no longer subject to section 37.2 agreements. This means that 37.2 agreements will have very little meaning and have no legal standing. Still there, but the act has no effect, or the agreement has no effect. So one wonders if it's worth having. I have already dealt with sections 37 and 38, which you will recall this was the offences and penalties. So you can go back to that particular video to have a look at that. So as I was saying about section 37.2, and one would actually like to read both of them. So this is what it used to say, or it still says. This is the current. Subject to provisions of section 10.4 and section 37.2, a provision of this act or a condition specified in any notice or direction issued thereunder or subject to which exception was granted to any person under section 40 shall not be affected by any condition of any agreement, whether such agreement was entered into before or after the commencement of this act, or before or after the imposition of any such condition as the case may be. So now there's a change, and you will see that on the side where we have the amendment, that has been removed. So subject to provision of sections 10.4 and 37.2, as I said just now, they are no longer there. It's been removed. So it just says a provision of this act or the conditions specified in any notice or direction issued thereunder or subject to which exemption was granted to any person under section 40 shall not be affected by any condition of any agreement, whether such agreement was entered into before or after the commencement of this act, or before or after the imposition of any such condition as the case may be. So basically what we were saying just now, that your 37.2 agreement is no longer here. The 37.1 is still in place. The 37.2 agreement almost is not worth having. So in section 43 regarding regulations, the minister may make changes or may make regulations with regards to health and safety issues or requirements. You can read that one for yourself. I'll go down to the bottom here, which is quite relevant, and that is the classification and labeling of hazardous chemical substances in the workplace. So pretty soon now we would have to go and consult the GHS tables and for chemical substances and the requirements to label these chemical substances. The addition of following paragraphs: the consultation and negotiation to conclude collective agreements between an employer, employees, representative trade unions on matters of health and safety. Section 44 deals with the incorporation of health and safety standards into the regulations. Here we are specifically referring to the South African national standards and the incorporation of those standards into these regulations. This section also deals with the approval of inspection authorities, where the Chief Inspector may, in writing, approve an organization that has been accredited by SANAS in terms of accreditation for the conformity assessment, calibration, good laboratory practices, okay, as an approved inspection authority for specifically defined work. You can also read back on that one. It also makes mention that the AIA, the approved inspection authority, shall in the prescribed format report to the Chief Inspector every 6 months on all activities relating to the approval granted and all recommendations made to the employer. Section 45, serving on notices. Let's touch on that one quickly. And the serving of notices, or a notice, where we say unless another method is prescribed, a notice under this act shall be served by delivering a copy thereof to the person upon whom it is served, by leaving such a copy at the usual place of residence or business of such a person, or by sending a copy by registered post to the usual place of residence. And finally, you can go for yourself and finish off by reading for sections 46 and section 47, 48, 49, and finally section 50. So that brings us to the end of this short video. Please go on to that link that you can see behind me there and access all of the comments made by the technical committee of SANAS. And with that, I wish you goodbye.